over a period of these 9 years and above, there were a number of issues which has come as a conflict of interest. The provisions of the IBC will prevail. Was the seizure of the assets by the Enforcement Directorate.
Good day. Welcome to the second edition of BW Legal World, BW Business World, Understanding Corporate and Business Law with Dr. UK Chaudhary. Dr. UK Chaudhary, thank you for joining us again. And last time you were talking about the amendments in IBC 2025, what are in the right way proposed, what will work, what may not work, what may still need changes. But let me now go into what has been the successes of NCLT and NCLAT, and let me also understand what are the contradictions that have come while implementing IBC, because there are other laws that have come in like the PMLA. So are there contradictions that are kind of hindering how the IBC process is moving?
Yes, see, over a period of these 9 years and above, there were a number of issues which has come as a conflict of interest between the provisions of Companies Act 2013, Companies Act 1956, the SURFACI provisions, the arbitration law, the pending judicial cases before the various courts and the other tribunals. Nothing really has stopped the working of the Insolvency and Bankruptcy Code. And in most of the cases, it has been resolved that the provisions of the Insolvency and Bankruptcy Code will take a precedent over all other legislations because of the inbuilt mechanism under the IBC, where it has already been provided under section 238 that the provisions of that act, when comes into a contradiction with any other legislation, the provisions of the IBC will prevail over the other legislations. But there have been certain practical problems. The first practical problem has been coming that the issues relating to the secured assets, that if the some financial institutions or some person is already sitting on the secured assets, then whether those secured assets will form part of the assets of the corporate debtor which is undergoing a CIRP or in the event of liquidation. Now that has already been interpreted that for that section 52 and section 53 have already provided that one can always relinquish the interest in the assets if one is a secured creditor, and in that eventuality the provisions of section 53, which is a waterfall mechanism, will provide that how the assets will be distributed or how the proceeds of the assets will be distributed. The another issue which has found lot of contradiction was the seizure of the assets by the Enforcement Directorate, which is popularly known as the ED. Now ED has a vast powers under the money laundering legislations, where they can go and seize the assets which has been acquired out of the proceeds of any illegal act which form part of the money laundering legislations. Now in that provisions, it has come number of times that if suppose the corporate debtors' assets have become the assets which are already seized by the money laundering agencies like the ED. So what will happen? How the successful resolution applicant or the corporate debtor in its information memorandum, or how the RP can inbuilt those assets in preparing for the successful resolution process. This has become a issue which number of courts have given a contradictory decision. Some of them have said that money laundering is a special legislation and therefore its provision will prevail over the Insolvency and Bankruptcy Code, where the assets are under the CIRP process. Similarly, there are some issues where they say that no, because of section 238, the provisions of the IBC will prevail over the provisions of the Money Laundering Act. Now, this issue, according to me, now will settled Not only that, because of the pending litigation before the Honorable Supreme Court and the number of decisions of the National Company Tribunal Appellate Authority, which have taken a view that no, the provisions of the IBC will take, and therefore the ED must hand over the assets to the resolution professional so that they can form part of the assets when it's in the CIR process. This will now become a further getting a statutory backing under the amended laws. In the amendment laws, there is a specific section provided that if there is any seizure by the ED, those assets will become part and parcel of the assets of the corporate debtor so that they are available to the resolution professional or they are handed over to the successful resolution applicant. This situation will no longer be required to go to the court because the statute itself has now provided for it.
Dr. Chaudhary, that brings me to, in your first episode, you talked about how creditors could take control earlier, right?
Yes.
Now tell me, is that a good situation? Is it a bad situation? Of course, it needs to be looked at case to case. But give me your comments on really is it a fair judicial process if the creditors take control earlier?
According to me, that if you care for my personal opinion, we are in a working democracy. We live in a largest democracy of the world. And in a democracy, the rule of law and the dispensation of justice, according to me, is the core area which must prevail over all other considerations. In that sense, if you look at the new provisions, which is known as the Creditor's Initiative Insolvency Resolution Process, or what we short in now abbreviated as CIRP. Now, in that sense, this CIRP, according to me, will fall flat when it is tested at the cornerstone of the dispensation of justice. Because it's not the entire only administrative process which take away the assets, even if it has a backing of the rule of law. Because after all, the Insolvency and Bankruptcy Code is also passed by the Parliament. Now, having passed by the Parliament become the law, if the law provides, but if it has to be tested that whether somebody is deprived of the assets without the due process of law, ultimately, even in this chapter, new chapter of the IBC, ultimately it has to be provided for that once there is a public announcement of the CIRP coming into place, in that situation also the promoters or the company will have a right to make an absolute challenge to such a process by filing an application before the National Company Law Tribunal. And the National Company Law Tribunal also have the choices. Number one, it can determine that there is no default has occurred. If there is no default has occurred, then it means that it can say and stop the process there and declare it as void ab initio. But if it finds that default has occurred, but all other process like the consent of the 51% is not obtained, or the necessary process as prescribed by law or by the rules has not been followed, then it can convert the CIRP into a CIRP, which means that it goes back to Chapter 2 insolvency, and the stage will be also decided by the National Company Law Tribunal. Therefore, according to me, after covering certain steps, we are back to the same process as started in Chapter 2.
Okay, now this also brings me to this point of, the process has sometimes led to asset sales and sometimes it has led to full turnarounds, or the company, continues to be going and progresses. Do you have a point of view on asset sale versus full turnaround?
See, according to me, the law the statute and the decisions have already provided for it. In both processes, either in the corporate insolvency resolution process or in the liquidation process, it has always been provided that CIRP can also happen in the stage-wise or by project-wise, particularly in the real estate. If a real estate company, let us say, is 10 projects, and the CIRP can be started only in one project, or it can be start in all the 10 projects. Similarly, there could be a CIRP successful with respect to one particular project, or with respect to two or more, or with all of them. Similar is the situation in the liquidation also. In a liquidation process also, the company can be sold as a going concern itself. Or if it is not possible to do so practically, then the assets can be divided into the various parts, and then it can be disposed of in the asset-wise position. Therefore, the law has already, according to me, taken care of both the situations. And in most of the time, people prefer that they take over a corporate debtor as a going concern.
Now, there is the issue of personal guarantees and, how the promoters deal with it. In the IBC amendments, again, the amendment makes it harder for promoters and personal guarantees to delay recovery through personal insolvency protections. What is your point of view on that?
According to me, that even this issue has already been sorted out by the various judgments of the NCLT, of the Honorable Appellate Authority, and eventually in the Honorable Supreme Court, wherein the constitutional validity of Section 94, 95 and other provisions have already been upheld by the Honorable Supreme Court. Now, the only new thing which I find out is the change in the certain definitions and the provisions, where it has become almost next to the impossible for the corporate guarantor to get away with their guarantees. It was already very difficult in the existing provisions of Section 94, 95, because already that this has been started with the process that this jurisdiction already conferred on the National Company Law Tribunal, and the DRT have still not been notified. But if we go by otherwise, and look that there is a further tightening of the noose, if I can call it that way, around the neck of the promoters and the corporate guarantors or the individual guarantors, it has become almost impossible that their all assets, including the personal assets, will be now open for recovery.
Fantastic. Now, let me ask you a qualitative question. From your learning of 9.5 years, you already in the first episode said that NCLT has done a fantastic job in spite of all the constraints and the fact that there was a learning curve. What do you think needs to be, you're a domain expert, suppose the government asked you for your advice on what should be changed, what should be added, what would be your recommendations?
See, my first recommendation will be that the timelines should be realistic. You must know the process of the court. And you must know that the process of court and the dispensation of justice is a time-consuming process. Therefore, you cannot legislate something where even the Honorable Supreme Court has to intervene and say that all these timelines under the IBC are directory and they are not mandatory. Now, if the court has to make this kind of pronouncement, it means that it has taken into consideration that these timelines have not been realistic. Therefore, if somebody asks me for my personal opinion, I will say, please, for God's sake, become practical. You have to give a timeline which must be achievable. So don't put something into the legislation which is impossible
to implement. Following all the provisions of natural justice.
I give you that when the Companies Act 2013 came, I personally gave a suggestion to the government that it's impracticable to ask the National Company Law Tribunal to dispose of a petition in terms of Section 424 within a period of 3 months. Please trust me that not a single petition in the last between 2013 and now 2025, not a single petition has been disposed of within a period of 90 days. So what is the point in having such a section in the Companies Act? Now you are having the same kind of dead letter timelines in the IBC. You have flooded the IBC with all kind of timelines. Something is to be done in 7 days, something to be done in 14 days, another to be done in 30 days, and another extension of only 45 days or 90 days or 150 days or 180 days plus 90 days, 270 days plus 335 days. What is this going on? You have to be practical. So that is my first suggestion is, please, for God's sake, be practical and provide the timelines which can be achieved by a judicial process which is in place in the country. Then number two, that according to me, you have to be fair to every person. The whole IBC has been framed with banks and financial institutions in mind. The operational creditors have been given a right to file a petition. But once a petition is filed, they are nowhere. Neither in the process of the CIRP nor in the recovery of the money. And it has become almost next to impossible for any operational creditor to recover its dues. And do you understand that the maximum number of the companies which support a manufacturing company are these operational creditors? There are the small companies, there are medium companies, there are the proprietary concerns, there are the individual proprietary companies which make supplies to the manufacturing companies or even to the service providers. But when it comes to the recovery, all monies are given only to the banks and financial institutions. This was completely, according to me, unfair. My second suggestion will be, please do apply mind and provide something for the operational creditors in the funds which comes into the coffers of the creditors committee through the process of the CIRP or in the coffers of the liquidator through the process of the liquidation. Provide something for the operational creditors.
Fantastic. Now, since you mentioned that it has been done primarily keeping the lenders, the banking and financial institutions into one of the segment of companies that has prospered in the last 9 years is the ARCs. They have really prospered, the asset reconstruction companies, because they are working in unison with the banks to take over the debt and then initiate the process and get the assets. I mean, look at the growth that the ARCs have happened. Would you like to comment to that?
Yes, see, I don't mind if anybody is prospering. If the ARCs are prospering, they are prospering because of their thoughtful ventures that they have gone into. But one thing is for sure, that the provision of the banks in terms of interest, penalties, penal interest is, according to me, again impracticable. They inflate the debt to such an extent that when the ARCs treat it as an NPA from them and purchase these NPAs, they purchase it at a cost. You understand how much? 20%, 30% of their value. And the banks are happy to clean their balance sheet by handing it over to the ARC. So if suppose 100 rupees as NPA is purchased by an ARC for 20 rupees, he doesn't go back to the CD for 20 rupees. He goes back to the CD for 100 rupees. And if out of 100 rupees, he recovers 80 rupees, see that how much profit he has made on that NPA. So this is the kind of, and I must say, it is their business, their way of looking at the business.
They're taking the risk.
Yes, they are taking the risk that even buying the NPA at 20% or 30% or 40%, he is taking a risk. So out of the risk, the larger is the risk, the larger is the profit. You have heard that saying. So this is happening. But the fact remains that even the ARCs are now using the IBC. And pure and simple, whether you call it a recovery or not, but in my personal opinion, this is nothing short of a recovery, even if through the resolution process or through the liquidation.
In this second episode, let me ask you, are there other contradictions, conflict of interest, like we talked about PMLA versus the statutes of law? are there any other aberrations? Okay, let me not say conflict of interest or contradiction. Other hindrances that may be cleared for IBC to be more effective?
According to me, not. But I see that there is one procedural difficulty which is coming in the way of expeditious disposal of these petitions is that most of the people, I'm telling you, even the framers of the law, are not aware that once a Section 7 or Section 9 petition is filed, in that one petition itself, there are number of interim applications. And in some of my own cases, that interim applications have multiplied to almost 150 interim applications. So one case, in fact, get converted into 150 cases. So it's not 7,000 petitions which are pending. It is 7,000 petitions multiplied by the interim applications. And each interim application takes the same time for deciding by the member as a original petition is taking. So it's not a question of the admission of the petition in 14 days. It's a question of ultimately deciding that petition and the interim application. Under there is one section, Section 60. There is subsection 5 in that section. Under Section 60, subsection 5, read with all other interim applications like the avoidance applications under Section 43, 45, 55, 66, fraudulent applications, extortionist transactions, all these applications when apply, the one petitions become actually 150 petitions. And that is one aberration which is coming in the way of deciding the cases, which nobody is understanding, neither the framers of the law nor the ministry, which has to provide for more members. That according to me, if I have the choice, if I have the ministry under my control, I will appoint minimum 200 members in the NCLT and make at least 200 courts.
Right now, there is a provision for another 50, taking it to 80. I mean, 30 is a provision, 28 are operational, and 50 have been advised to be more created. You're saying you'll take it to...
That is only a suggestion,
right.
But there is no amendment in the Act. The Companies Act still remains 63.
So you will take it to 200.
If you have to take it to 200, you have to amend not only the Companies Act, but then the ministry has to be supportive. And there have to be a budget allocation accordingly. Right now, as I said, that the Honorable Supreme Court in 2010 stated very clearly that the status of the NCLT has to be the status of the High Court of a state. It has not come to that level at all.
I'm sure with your passionate, inputs and your standing in the profession and your understanding of IBC, and maybe through this video, it reaches out to the right stakeholders, and there is some impact of what you are saying. You have a voice in the community. You also have a voice amongst decision makers, policy makers. So I'm sure you're bringing these nuanced issues to the forth and also giving solutions. And the fact that you believe that NCLT has done a great job in spite of all these, let's say, constraints, if I may use that word. I'm sure the positive intent in your pointing out these aspects is understood, and there is action. When we talk to you in the third episode, we'll talk about some other issues that are currently impacting corporate and business law. For now, it's a wrap on the second edition of the Corporate and Business Law with Dr. UK Chaudhary. Stay tuned, give us your comments, feedback, and we'll take those up with Dr. Chaudhary. If you have questions for Dr. Chaudhary, we'd love to take it in the third episode. Thank you. God bless you.
Thank you. Thank you very much.